considering the fact that we don't live in a world in which the majority of cases go to trial, we actually live in a world where 95% of cases are pled, I think Padilla was the catalyst or the beginning of the conversation to talk about where do we go from here and recognizing that times have changed. Also, when we think about the fact of 80% of people who go through the criminal justice system are poor, and that in terms of especially immigration consequences where you don't have a right to an immigration attorney, that also plays a big important role as to the conversation that takes place between appointed counsel and the defendant. Now, in terms of immigration consequences, I'm sure all of you know that the amount of people who have been removed from this country has grown dramatically. In the 80s, less than 2,000 people were removed based on a criminal conviction. In 2010, 387,000 people were removed from this country, of which 169,000 of those were removed based on a criminal conviction. Now, the other problem with that, right, is the fact that immigration consequences of criminal convictions, because of the change in immigration law, if you are convicted of a crime, a lot of people have no remedy in immigration court. So if you can't avoid the criminal conviction, there's no hope for you in the future, right? So that makes it even more important that you receive this advice in the criminal justice system. Now, we're not only talking about the defendant, we're also talking about people, their families, right, and the community in which they live. 10%, it's estimated that 10% of families live in a mixed family household. That means that there's someone who is a US citizen and someone who is a non-citizen. And as a result of these mixed family households, it's estimated that over 100,000 parents have been removed that have US citizen children between 1988 and 2007. Over 1 million individuals have been deported, and that the communities in which they live, there have been economic signs of those communities have faltered due to bankruptcy and have reached other economic stresses that were not present before these mass deportations. Now, in terms of collateral consequences, which Padilla does not technically address it, but we're still going to talk about it because it is, again, the beginning of that conversation, that in the US, it's estimated that approximately 70,000 collateral consequences exist as a result of a criminal conviction, right? So again, when you look at all this, it is really important that we start this discussion in order to really talk about what we can do in the criminal proceedings, or at least the criminal justice system. Everyone cheered, but what was happening is, right, that it was actually what I call a two-tiered admonishment. So it wasn't actually, it was a win, but it was a win that was complicated and complicated things. Because as we know, Justice Stevens said, well, if the immigration consequences are clear, succinct, and explicit, right, according to the statute, that defense counsel is advised to give the specific risk of deportation. However, if it is not straightforward and succinct, defense counsel need do no more than say it may carry a risk of deportation, and if you want more information, please check with your immigration attorney, which, as we know, there is no right to one, and since 80% of people are indigent who go into this system, the likelihood of that happening is pretty much non-existent. If I have to, as defense counsel, determine whether immigration law is succinct, clear, and explicit or not, how am I going to negotiate a plea in some circumstances? I think if one example is clear, for instance, under immigration law, theft, where you are sentenced to 1 year or more in jail, is considered an aggravated felony. And for for anyone who doesn't know, aggravated felonies for lawful permanent residents are the kiss of death, right? There is basically really no remedy to get out of it, and you will be deported. So you open up the statute, as Justice Stevens said, you know, if you open it up and it's there, it's easy enough, right? So you open it up and it's there. Now, one can argue, well, it's easy enough to know, okay, my client is charged with a theft, and the plea the settlement offer is 366 days. Well, I know that's more than a year, right? And so I know that my client who is a lawful permanent resident, is facing an aggravated felony, so I can tell him what the specific risk of deportation is. If you plead guilty to this charge with this plea, right, you will be subject to deportation because you will be convicted of an aggravated felony. All right, I've told him the specific risk of deportation, and now, because I also have a duty to negotiate under the Sixth Amendment, I can then go to the prosecutor and say, well, can you give me how many? 364 days, right? Because again, I know an aggravated felony for theft, it has to be a year or more. So if I get my client under a year, that's no longer an aggravated felony. And at least for those purposes, he is out of it, right? I can do that. However, what happens if it's not succinct, clear, and explicit? Or let's say it's just a theft charge and it's 30 days in jail. Well, technically we know theft at that point is not an aggravated felony, but if I open up the statute, it doesn't say much about theft, but there is something called the lovely crime of moral turpitude, right? Crimes of moral turpitude are defined as intrinsically and morally reprehensible. Well, that gives us a lot of guidance. So the question then becomes, since it's not clear in the book, right, do I just then tell my client, well, sorry, you're charged with theft. I couldn't find it in the Immigration and Nationality Act, so it may affect your immigration status. When for many of us know that if we go to practitioner books, which Justice Stevens talked about that competent counsel would do, you would know that theft in most circumstances is a crime of moral turpitude, right? And if you go to the statute, people with crimes of moral turpitude under certain conditions can be deportable. Again, how far do you go to be able to do this? And it doesn't necessarily mandate plea negotiation, at least in the specific opinion, but it does, specific wording, but it does in the opinion.